Good morning, everyone. Thank you, Darren. For my part, I'll be providing an update on a bit of everything. So as part of its last election promise, the incumbent government announced a measure to improve multinational corporate transparency through implementing a public registry for beneficial ownership. So the exposure draft was released in late 2024 to amend the Corporations Act, really with the policy intent to increase the availability of beneficial information to discourage the use of complex structures by really to showing ultimately who owns, controls, or profits from a company, and to increase the tools available to regulators and law enforcement in performing their duties, for example, assessing foreign investment applications, enforcement of sanctions, etc. So some of the proposed changes include enhancing the disclosure requirements for Australian listed foreign entities, which are currently not subject to the same disclosure requirements as compared to your domestic entities, and to improve access to information for journalists and academics, and really to expand the definition of what a relevant interest is to include derivatives, which really arrangements that can influence entities, companies' direction. And finally, to improve SICs regulatory enforcement powers by expanding the use of freezing orders and your tracing notices. So amendments were passed last week to deny income tax deductions for amounts of general interest charges and shortfall interest charges incurred by a taxpayer from on or after 1 July 2025. So this bill was in limbo for a bit, but was actually passed in the last week in the final sitting before the election was called. So during consultation, there were discussions about whether should they retain the deductibility of the interest but increasing the interest rate. However, ultimately there was no change. That's because the view was that this allowing the deductibility would be consistent with your general treatment of penalties, which are non-deductible, and get the most punitive effect to really get people to discourage late payment of tax. This is because, as at the end of last calendar year, the debt book of the ATO is sitting at $52.8 billion. So in case people are unsure what's the difference between SIC and GIC, so SIC is really interest charges that arises from your ATO reviews and audits and accrues from the original due date of the tax liability to the day the ATO issues an amended assessment. Whereas your GIC is really just late payment for tax liability, really to encourage people to pay your tax on time. So taxpayers will continue to have the ability to apply for a remission, and the commissioner still has the discretion to remit any GIC or SIC payable in accordance to the practice statements. But as we all know now, it's getting increasingly harder to get a remission from the ATO. So there's also no grandfathering or amnesty for existing debts. So please bear that in mind. So as Darren spoke about debt creation, PCG, and I'll be talking about a couple of others, I just thought that it would be good to just have a quick slide on what PCGs really are. So in addition to public rulings that are binding to the commissioner and illustrate the commissioner's view and interpretation of the law, so the ATO is actually increasingly issuing PCGs, which is more behavior driven and explains how the ATO will allocate its compliance resource according to an assessment of the risk. So it may also outline administrative approaches, that they would use to mitigate practical difficulties in operating the law, and I guess the type of documentation, for example, which Darren alluded to earlier, that they consider as relevant in assessing the risk. So arrangements in green zone will still be reviewed, however, really to the extent to confirm that the taxpayer meets the requirement. So as you can see, taxpayers can actually swim between the flags by positioning themselves across the risk spectrum. So as long as you're not in the red, you'll be fine. Just bear in mind that whilst rulings are binding to the commissioner, the PCGs are not. However, it will contain clear statements as to how they can be relied upon by the taxpayers and the type of taxpayers that it applies to. So in December last year, the Commissioner issued a draft PCG relating to arrangements where the integrity measure per section 207159 may apply. So this section talks about making frank distributions made on or after 28 November 2023 unfrankable. So the summary of the legislation is on the screen, on the slide, but really you will want to fall into the green zone, which is the low risk scenarios. So basically a situation is low risk if the distribution is consistent with the past practice over the past 3 years of distributions paid. If your arrangement involves a dividend reinvestment plan that's undertaken for normal commercial purposes, or the issue of your equity interest is less than 5% of the entire frank distribution, so these are all green zones. If the issue of equity interest is subject to regulatory requirements from EPRA or SIC, that's also fine. So, and in the case of private companies, if the distribution is made under an arrangement where the capital raising and distribution is initiated to facilitate the departure of a shareholder, for instance, for succession planning or sale of the business, that should be fine. So your red zones are your typical really contrived arrangements or that there's lack of genuine commercial purpose. And the other two really red flags to note is that if there's a close alignment of your raising and the issue of your equity, if that happens within 12 months, that's a red flag. And if there's a special dividend that's declared, which is unusually large as compared to your previous ones, and there is no corresponding increase in your profit, that would be a red flag from the ATO's perspective. So if you attended the session last year, you may recall we spoke about the tax ruling TR 2024/D1, which sets out the commissioner's view in respect of this overseas payment made for software arrangements that may be characterized as royalties. So 1 year on, the ATO has still yet to finalize this ruling because they want to incorporate some court findings that will be relevant to the arrangements. This is because for any intellectual property arrangement, the ATO strongly relies on the position that there are embedded royalties in the agreement that do not provide for payments of the use of the copyright or the IP, which really should be apportioned. So the first case that we are looking at is the Oracle case, which is handed down in October last year. So where Justice Perham denied Oracle's stay application, which is to temporarily halt the domestic legal proceedings to pursue a mutual agreement procedure under the Australia and Ireland Treaty, really to pursue international arbitration. So at the heart of this dispute is really what the definition of a royalty is under the Australian treaties. In this case, so Oracle Australia purchased enterprise software and hardware from Oracle Ireland and distributed these products in Australia through complex contractual arrangements. And this includes using programs where Ireland owns the copyright too. So then there's a sub-licensing fee is paid from Oracle Australia to Ireland. So and if this sub-license fee is made to Ireland is found to be royalties, defined as royalties. So then it's subject to withholding tax, royalty withholding tax. So in his position, Justice Perham said that both sides had good reasons for their position. So the question was whose position reasons were better. And ultimately, the commissioner prevailed in this instance because of public interest and the need for a test case. So this is because, according to the ATO, they are actually currently running 15 other audits on distribution arrangements that requires the definition of a consideration of what's royalty for Australian tax purpose. And then this judicial decision will be useful in guiding the commissioner and this 15 taxpayers whether their arrangement is similar to the Oracle ones and whether ultimately it involves royalties or not. Then you will be provide guidance to finalizing ruling. And I guess the juicy bit is that this commissioner's approach has also triggered some sort of geopolitical tension, with the US Treasury actually making a complaint that, with the non-conformity of the commissioner's position against the OECD commentaries on software distributions. And finally, because it is one of the first few MAP cases, it will also provide the procedural guidance on how it should be run. So we also spoke about PepsiCo versus the commissioner last year. But since then, the full federal court majority has overturned the original decision, which was in the commissioner's favor. So the High Court hearing for this case is actually tomorrow and Wednesday. But as the judgment is rarely delivered immediately after the hearing, so it might take weeks or months before we know what the final decision is. But really, the crux of this issue is that the commissioner contended that the royalties for the use of the Pepsi trademark were embedded with the payments for the supply of the cola concentrate, such that they were licensed to the third-party bottler for free. And then payments were redirected from the PepsiCo to the reseller of the concentrate, who is not a party to the bottling arrangement. So in overturning the original decision, the majority in the full federal court was of the view that the parties were actually dealing at arm's length, and they engaged in extensive bargaining to come to the terms of the bottling arrangement, and that those payments were in part consideration for the use of the IP. So really, the legal form of the contract trumps the substance. So basically, really limiting to the terms of the contract. And also, in essence, the court has cast doubt over, the commissioner's concept of what there should be an embedded royalty in your payment. So like I said, it's tomorrow. So the three questions really that the High Court will be considering tomorrow are: one, whether is there really a royalty? So the commissioner's view is that even though there's a single payment, the agreement was in part a license to use the highly valuable trademark and intellectual property of the Pepsi logo and stuff, but in part also to confer other rights like your bottling and your distributions. So it is commercially unreasonable that for the bottler to be provided with the use of the IP under the license, under the agreements, but without really attributing part of the payment to those rights. So in short, really, can multinational licenses valuable IP for free by contractually stipulating that these amounts are payable under the licensing agreement for something entirely different other than the IP. But I said in the case that nothing was paid to the US IP holders. So if question one is accepted that there is part in the payment was part in use for the IP, then really question two is more about redirecting. Was it a payment redirection from really from the US parent to this supplier of the concentrate, even though the concentrate entity is not contractual, it's not part of the contract, and all the legal obligations, whether to sue for a breach of contract or obligations for payments, is all between Pepsi and the bottler. And the final third question is, would the diverted profit tax apply to this arrangement? So the commissioner's alternative postulates were rejected in the full federal court, but the commissioner disagrees because his view is that his alternative postulates are not of what might reasonably happen. It's not detrimental or it's not unreasonable, that adds complexity to the commercial negotiations between the bottler and Pepsi. And even if it's unreasonable, the taxpayer, being PepsiCo, has not discharged its onus of proof by regard of the tax benefit by explaining what would happen absent the scheme. So, and this is contradictory to, I guess, the decision in Guardian in another Part 4A case, which clearly says that, the taxpayer also has the onus of proof. So lastly, I just want to talk about another PCG that's to be published, which sets out the technical view in the draft software ruling. So this was meant to be released for public consultation in Jan this year, but with numerous delays, and now it's scheduled for mid-2025 because the government has gone into caretaker mode. Nevertheless, because this is extensively discussed in different forums, what we know so far is that the PCG will be green zone focused and will illustrate situations where the ATO will apply minimal to no resources. And some of the scenarios really include if your software is acquired for private or domestic use, or primarily used in the course of your own business, that's fine. So if software that's bought off the shelf and not subject to any after service or customization, that should be fine as well. And I guess the one that people are most interested in is if the software is an inseparable part of a tangible good. For example, the examples given by the ATO was like a car or a washing machine. So the software that's in the tangible good that's also royalty free. The ATO wasn't intending to issue a red zone example, but has since acknowledged that because there's a lot of public interest on what that is, so they may consider including one in the future when it's published. And another thing to note is that because the ATO's default position is to deem the whole payment to be royalty if there was no apportionment, this PCG will also provide guidance on what's a residual calculation. So this calculation is not intended to work out the quantum of the royalty, but instead work out a measure of risk, again, over a spectrum to indicate how risky your arrangement is. So the delay in finalizing this software is unlikely to deter the ATO from conducting audits on this arrangements. So we encourage clients to really, when you've made an overseas payment that could be royalty, you should look at contracts of existing arrangements and whether this payment is blended with an element of IP, even though it might be named something entirely different, just to have to think about whether it's really a royalty.